You are listening to HOA Karen Patrol. She said "tow on site," and she meant me. I stepped into the driveway, and Karen screamed that driveways were not for parking during enforcement hours. You are not going to win this. Her voice cut through the midday heat like a siren. I had just rolled in after a 12-hour shift, my sedan still ticking as it cooled, and Katherine Jackson was already standing at the curb with a clipboard and a tow truck idling behind her. The wheel lift was half raised, the hook chain swinging in the bright Nashville sun, and she was pointing at my windshield like I had parked on a landmine. I work as a rideshare driver. My car is not a luxury. It is my income, my schedule, my entire ability to pay rent in this Golden Mesa HOA hellhole. I moved here 6 months ago because the rent was manageable and the complex was close to the airport. Nobody mentioned that the board president treated parking like a blood sport. Katherine moved closer, her black blazer sharp against the pale concrete. She had a zip tie bundle in one hand, waving it like a badge. The rules do not care about your excuses, and neither do I. She said it twice in the same breath, louder the second time. I glanced at the tow truck driver. He was leaning against the cab, arms crossed, waiting for the green light. I took a breath. What enforcement hours? I live here. This is my driveway. She tapped the clipboard. Guest parking is restricted between 10 in the morning and 4 in the afternoon on weekdays. Your vehicle does not display a valid resident decal in the approved location. Therefore, it is classified as guest parking, and you are in violation. The tow company has been authorized by the board. I pointed at the registration sticker in the corner of my windshield. It is right there. She leaned in, shading her eyes with one hand, then straightened. That is not visible from enforcement distance. The decal must be centered and unobstructed. Your paperwork is cute. Mine has a letterhead. The truck engine revved. I felt my stomach drop. I could not afford the tow fee. I could not afford to miss tonight's shift. I held up both hands, keeping my voice level. I kept my hands open and my voice calm because the real move was still ahead. Let me get the decal right now. I will fix it. Just give me 10 minutes. Katherine smiled. It was not a kind smile. The authorization has been issued. The process is already in motion. You should have complied with the notice. What notice? She pulled a folded paper from her pocket and held it up, not close enough for me to grab. A bright tow warning sticker had been slapped on my driver's side window 2 days ago while I was out on a long haul. I had peeled it off, thinking it was a prank. Now she was holding a photocopy of the placement photo, dated and time-stamped, with my plate visible. You received written notice. You ignored it. Now the vendor is here. She turned and waved the driver forward. I moved between the truck and my car. Wait. I will pay the fine. I will get the decal. Just stop the tow. Katherine stepped closer, her voice dropping to something colder. The fine is $250. The tow fee is another $375 if the vehicle leaves the lot, plus daily storage. Your payment is due now, and the HOA office does not accept cash. Check or money order only, and the office closed at noon. It was 1:15. I pulled out my phone. I will transfer it. I will call the management company. She shook her head. Transfers are not accepted for enforcement actions. You can dispute the fine at the next board meeting. That is in 3 weeks. Until then, the vehicle will be held as collateral. The driver moved in fast. He had a tire clamp in his hands, the kind with a bright yellow boot. He dropped it onto my front wheel and snapped it shut mid-argument, the sound like a prison door locking. Catherine treated it like a win, stepping back and folding her arms. Now the vehicle is immobilized pending compliance. I stared at the clamp. My chest was tight. I had a home health aide arriving at 3 to check on my father, who lived with me. The aide parked in the guest spot near my unit because it was the only accessible space. If Catherine towed that car too, my father would miss his medication window. I stood up. Catherine, the aide is coming at 3. You cannot tow that car. She checked her watch. Then they should display a valid guest pass on the dashboard, visible from outside, with the unit number and expiration time filled in legibly. No pass, no parking. The rules do not care about your excuses, and neither do I. I felt the heat rising in my face, but I swallowed it. I pulled out my phone and opened the camera. I am documenting this. Catherine did not flinch. Go ahead. Everything I am doing is authorized by the board and outlined in the CCRs. Your documentation will not change the outcome. I took photos of the clamp, the tow truck, Catherine holding the clipboard, and the photocopy she had waved at me. She watched me do it, her expression flat. When I was done, she turned to the driver. Proceed with the tow. He nodded and started cranking the wheel lift. I stepped back, pulling up the management company number on my phone. A recorded message told me the office was closed until Monday. It was Friday. I tried the emergency line. It rang 4 times and went to voicemail. I left a message, keeping my voice steady, explaining the situation. Then I called a friend who used to work in property management. She picked up on the second ring. Hey, I need advice fast. The HOA is towing my car out of my own driveway, and they are claiming I do not have a visible decal. She paused. Do you have proof you are a resident? I have my lease, my registration, my mail, everything. Then they cannot tow you without due process. That is conversion. Tell them you are calling the police. If you are enjoying this story, please hit like and subscribe for more wild HOA nightmares. I looked up at Catherine. I am calling the police. This is conversion. You cannot tow my car without proof I am not a resident. Catherine did not blink. The board has determined that your vehicle is in violation of guest parking restrictions during enforcement hours. That is not conversion. That is compliance. If you have a dispute, file it with the board secretary in writing. I dialed 911. The dispatcher answered. I explained the situation, keeping it factual. The dispatcher said an officer would be out within the hour, but that civil disputes over parking were typically handled by the parties involved unless there was evidence of theft or fraud. The officer arrived 40 minutes later. By then, the wheel lift had my front wheels off the ground. The officer was polite, but firm. He checked my registration, my lease, and Catherine's authorization letter from the board. He asked Catherine if the HOA had filed the proper lien or notice with the county. She said the HOA did not need to file anything because this was an internal enforcement action under the CCRs. The officer looked at me. Do you have a copy of the CCRs? I did not. I had been given a welcome packet when I moved in, but it was a thin, glossy folder with a map and a list of amenities. No rule book. The officer sighed. This is a civil matter. If you believe the tow is unlawful, you need to file a complaint with the management company or take it to small claims court. I cannot stop the tow unless there is evidence of a crime. Catherine handed him a business card. The tow vendor is licensed and bonded. The board has full authority to enforce parking under the CCRs. If he wants his car back, he can pay the release fee at the yard. The officer handed me the card. I am sorry. There is nothing I can do here. The truck pulled away with my car at 2:45. I watched it disappear around the corner, the hook chain swinging. Catherine folded her clipboard and walked back toward the clubhouse without another word. I stood there in the empty driveway, my phone buzzing with a calendar reminder. The aide was due in 15 minutes. I called her and explained the situation. She said she would park on the street and walk up, but that if the HOA towed her car, she would not be able to come back. I told her to display the guest pass I had picked up from the office last week. She said she would, but that she had heard stories about this complex and was not optimistic. She arrived at 3:10. She parked in the guest spot with the pass clearly visible on the dashboard, unit number and expiration time filled in with a thick black marker. I watched from the window as she got out, locked her car, and walked to my door. No tow truck appeared. Not yet. The aide finished her visit at 4. She left without incident. I watched her drive away. Then I sat down at my kitchen table and opened my laptop. I started researching Tennessee HOA law, towing regulations, and conversion statutes. I also opened a new folder on my desktop and labeled it Evidence. I spent the weekend at the tow yard. The clerk was a tired-looking guy in his 50s who kept apologizing and saying the HOA authorization was missing from the file. He said he could not release the car without proof of payment or a signed release from the board. I showed him the photos I had taken, the lease, the registration, everything. He shook his head. I do not make the rules. You need the board to sign off, or you need to pay the full amount and dispute it later. The full amount was $625. Tow fee, 2 days of storage, and an administrative charge. I did not have it. I called Catherine. She did not answer. I left 3 messages. No response. On Monday, I went to the management company office. It was in a strip mall on the edge of town, wedged between a nail salon and a tax prep place. The lobby was small and beige, with a fake plant in the corner and a receptionist behind a plexiglass window. I explained the situation. She looked up my account and frowned. There is a note here that says your vehicle was towed for a guest parking violation. The board president filed the authorization on Friday. I need to dispute it. I am a resident. I have proof. She handed me a form. Fill this out and submit it to the board secretary. The next meeting is in 2 weeks. 2 weeks. My car would rack up 14 days of storage fees by then. I filled out the form anyway, attaching printed copies of my lease, registration, and photos. I also requested a copy of the CCRs and the guest parking policy. She said it would take 3 to 5 business days. I walked out into the parking lot and called my friend again. She told me to file a small claims case against the HOA and the tow company for conversion, and to request an emergency hearing to get the car released. She also told me to document every interaction and to get witness statements if possible. I spent the next 3 days gathering evidence. I took photos of other cars in the complex, all parked in driveways, all without visible decals. I counted 12 vehicles with the same setup as mine, registration stickers in the corner, no center decal. None of them had been towed. I printed the photos and made a comparison set, date stamped, with unit numbers blacked out for privacy. I also went back through my phone and pulled the doorbell camera footage from the day Catherine had placed the warning sticker. The timestamp showed her arriving at 9:30 in the morning, placing the sticker, taking a photo, and leaving. She had not knocked. She had not left a notice on my door. She had not called or emailed. Just the sticker, placed while I was out, and removed by me 2 days later because I thought it was random vandalism. I saved the clip to 3 different places: my phone, my laptop, and a cloud drive. Then I sent a copy to my friend with a note. "This is my trump card. Do not let me use it too early." On Thursday, I received a red-stamped envelope in my mailbox. It was from the HOA. Inside was a final notice for unpaid fines, including the tow fee, the guest parking violation, and a new charge for failure to display a resident decal. The total was now $900. Payment was due in 7 days, or the account would be sent to collections, and a lien would be filed against my unit. I called the management company again. The receptionist said the board had the authority to assess fines for violations, and that I would need to dispute the charges at the next meeting. I asked if I could attend the meeting remotely. She said no, in person only. I asked if I could bring a witness. She said yes, but that only residents could speak during the open forum. Witnesses could observe, but could not address the board unless invited. I thanked her and hung up. Then I called my friend and asked if she could come to the meeting. She said yes, and that she would bring her old employee badge from the management company she used to work for. It is not valid anymore, but it might make them think twice about lying. The meeting was scheduled for the following Tuesday at 7 in the evening in the clubhouse community room. I marked it on my calendar and kept gathering evidence. On Friday, I received another envelope. This one was not from the HOA. It was from a local law firm, addressed to me with a case number printed on the front. Inside was a summons for a small claims hearing. The plaintiff was the Golden Mesa HOA board. The claim was for unpaid fines and fees totaling $900, plus court costs and attorney fees. I read the document 3 times. The hearing was scheduled for 6 weeks out, which meant the tow fees would keep accumulating and the lien would be filed long before I had a chance to present my case in court. Catherine was trying to force me into a corner, and she was using the legal system to do it. I called a consumer rights attorney. He listened to my story and said I had a strong case for wrongful towing and selective enforcement, but that litigation would take months and cost more than the car was worth. He suggested I try to resolve it at the board meeting first, and that if that failed, I could file a counterclaim in small claims for conversion and request damages. I thanked him and hung up. Then I went back to my evidence folder and added a new section, Board Meeting Strategy. On Monday, I went to the tow yard one more time. The clerk said the authorization was still missing and that the HOA had not returned his calls. He said he was required to hold the vehicle until the board provided written release, or until I paid the full amount, which was now over $700 with the added storage days. I asked if I could see the original tow order. He hesitated, then pulled a file from a drawer. The order was on Golden Mesa HOA letterhead, signed by Catherine, dated the Friday of the tow. It listed my plate number, the violation, and the authorization for immediate removal. At the bottom, in small print, was a line that said the vehicle owner had been notified in writing at least 48 hours prior to tow. I took a photo of the page. The clerk did not stop me. That night, I printed the photo and compared it to the doorbell footage timestamp. The sticker had been placed on Wednesday at 9:30 in the morning. The tow had happened on Friday at 1:15 in the afternoon. That was 48 hours and 45 minutes. Technically compliant, except that I had removed the sticker on Wednesday evening, which meant there was no notice on my vehicle on Friday morning. I added the timeline to my evidence folder. Tuesday arrived. I got to the clubhouse at 6:45, carrying a folder with printed copies of everything: the photos, the timeline, the doorbell footage stills, the comparison set, the tow order, and the CCRs I had finally received from the management company. My friend met me in the parking lot. She was wearing a blazer and carrying a leather portfolio. She looked official. We walked in together. The community room was set up with rows of folding chairs facing a long table at the front. Catherine was already seated at the center of the table, flanked by two other board members I did not recognize. There were about a dozen other residents scattered in the chairs. Most of them looked bored. Catherine called the meeting to order at 7 sharp. She went through the standard agenda: approval of minutes, treasurer report, committee updates. I waited. My item was listed under new business, third from the bottom. At 7:35, Catherine called my name. She read the violation summary from a printed sheet: failure to display resident decal, guest parking during enforcement hours, failure to comply with written notice, unpaid fines totaling $900. I stood up. I was not given proper notice. The sticker was placed while I was out, and I removed it the same day because I thought it was vandalism. I did not receive any other communication until the tow truck arrived. Catherine looked at me over her reading glasses. The photographic evidence shows the notice was placed on your vehicle at 9:30 on the morning of the incident. You had 48 hours to comply. You did not. I held up the doorbell footage still. The sticker was removed by me at 6:15 that evening. There was no notice on my vehicle on Friday morning. Catherine did not look at the photo. Removal of an official notice is a separate violation. You are responsible for compliance regardless of whether the physical notice remains on the vehicle. The written record stands. I opened my folder and pulled out the comparison photos, then explained why 12 other vehicles in this complex have the same registration setup, parked in the same way, with no fines and no tows. Catherine glanced at the photos, then set them aside. Those vehicles are not under review at this time. This meeting is about your violation. I felt my friend shift beside me. She stood up. My name is Rachel. I used to work for the management company that oversees this HOA. I am here as a witness. I have reviewed the evidence, and it is clear that this is selective enforcement. The CCRs state that all residents must be treated equally. If one vehicle is cited, all vehicles in the same condition must be cited. That did not happen here. Catherine set down her pen. The board has discretion to enforce violations as observed. We are not required to cite every vehicle simultaneously. The policy is applied as resources allow. Rachel leaned forward. Then the policy is not being applied. It is being weaponized. And that is a violation of the Fair Housing Act. Catherine's expression hardened. This is not a fair housing issue. This is a parking issue. If you continue to disrupt the meeting, I will have you removed. Rachel sat down. I stayed standing. I have a video clip that shows you placing the sticker and leaving without knocking or providing any other notice. I also have proof that the tow order claims I was notified in writing 48 hours prior, but the sticker was removed by me within 9 hours of placement. The board is either lying about the timeline or ignoring the evidence. Catherine stood up. The board has reviewed the evidence and determined that the violation stands. If you wish to dispute the fines, you can file a formal appeal with the management company. This meeting is not the venue for litigation. I pulled out my phone. I have the video. I can play it right now. Catherine held up one hand. The board does not accept video evidence during meetings unless it has been submitted to the secretary in writing at least 72 hours in advance. You did not do that. Your evidence is not admissible. I kept my voice calm. Then I am submitting it now for the record, and I am requesting that the board vote on whether the tow was justified. Catherine sat back down. The board does not vote on individual violations. That is an administrative matter handled by the compliance officer. If you have a dispute, file it with the management company. Rachel stood up again. The compliance officer is you. You are the board president and the neighborhood watch liaison. You placed the sticker, you filed the tow order, and you are now refusing to review the evidence. That is a conflict of interest. Catherine did not respond. She looked at the other two board members. They both looked uncomfortable, but neither said anything. I tried one more time. I am asking for a motion to suspend the fines and release my vehicle pending a full review of the evidence by an independent third party. Catherine shook her head. The board does not have the authority to override a vendor contract. The tow company was authorized by the board, and the fees are between you and the vendor. If you want your car back, pay the fees and dispute the charges later. I sat down. My hands were shaking. Rachel leaned over and whispered, "They are stalling. They know they are wrong, but they are betting you will give up." I did not give up. I filed a counterclaim in small claims court the next day, requesting damages for wrongful towing, conversion, and selective enforcement. I also filed a complaint with the Tennessee Real Estate Commission, alleging that the HOA was operating outside the scope of its authority and that the board president had a conflict of interest. The clerk at the courthouse said the hearing would be scheduled in 4 to 6 weeks. I thanked her and left. 3 days later, I received another red-stamped envelope. Inside was a notice that the board had filed a lien against my unit for unpaid fines. The lien amount was now $1,200, including attorney fees and court costs. The notice said the lien would be recorded with the county within 10 business days unless payment was received in full. I called Rachel. She said the lien was likely unenforceable because the fines had not gone through proper due process, but that it would still show up on my credit report and make it impossible to sell or refinance the unit. She also said that the board was escalating because they knew I had evidence and they were trying to bury me in legal costs before I could use it. I asked her what I should do. She said, "Wait for the hearing. Do not pay them a dime. And when you get in front of the judge, play the video." I waited. The storage fees kept piling up. I borrowed a car from a friend to keep working my rideshare shifts. The home health aide kept coming, parking on the street, walking up. No one towed her car. Not yet. 2 weeks before the hearing, I received a call from a number I did not recognize. I answered. A man introduced himself as the former operations manager for the management company that oversaw Golden Mesa HOA. He said Rachel had given him my number and that he had some information I might find useful. I asked what kind of information. He said, "I quit 6 months ago because the board president was falsifying records and selectively enforcing rules to target residents she did not like. I kept copies of the original meeting minutes before she edited them. If you need proof, I can send it to you." I met him at a coffee shop the next day. He handed me a flash drive with 3 years of meeting minutes, correspondence, and internal memos. He said Catherine had been editing the minutes after meetings to remove dissenting votes and to add enforcement actions that had never been discussed. He also said she had a standing arrangement with the tow company to split the fees, which was illegal under Tennessee law. I asked if he would testify. He said yes, but that he wanted immunity from any retaliation. I told him I could not promise that, but that I would make sure his name stayed out of it unless absolutely necessary. He nodded. Just make sure she does not get away with it. I spent the next week reviewing the files. The original minutes showed that the guest parking enforcement policy had never been approved by a vote. Catherine had added it to the CCRs unilaterally after the fact and had backdated the amendment. The files also showed that she had towed at least 6 other vehicles over the past year, all owned by residents she had personal disputes with. I added the files to my evidence folder and sent a copy to Rachel. She called me an hour later. This is huge. If you can prove she edited the minutes and that she has a financial arrangement with the tow company, you can get the entire board removed. You might even be able to force a special election. I asked how. She said, file a motion to compel the management company to produce the original minutes. If they match the files from my contact, the board is done. I filed the motion the next day. The management company responded within a week, stating that they did not have the original files and that the minutes on record were the official versions. I submitted the flash drive as evidence and requested that the court order the management company to search their backup systems. The judge granted the motion. The management company was ordered to produce all meeting minutes, correspondence, and internal memos related to parking enforcement for the past 3 years. They had 10 days to comply. On day 9, I received a call from the management company receptionist. She said they had found the original files on a backup server and that the attorney for the HOA had requested a private meeting with me before the hearing. I asked why. She said the attorney wanted to discuss a settlement. I called Rachel. She said, "Do not settle. You have them. If you walk away now, they will do this to the next person. Make them face the consequences." I agreed. I called the attorney back and declined the meeting. The hearing was held on a Thursday morning in a small courtroom downtown. Catherine was there with the HOA attorney, a sharp-looking woman in a gray suit. The tow company owner was there too, sitting in the back row with his arms crossed. Rachel sat beside me. The former operations manager sat 2 rows back, just in case. The judge called the case. The HOA attorney went first, arguing that the tow was authorized under the CCRs and that I had been properly notified. She submitted the tow order, the photographic evidence, and the signed authorization from Catherine. Then it was my turn. I stood up and handed the judge a binder with printed copies of everything: the doorbell footage stills, the comparison photos, the timeline, the original meeting minutes, and the financial records showing the fee split arrangement between Catherine and the tow company. The judge flipped through the binder for 10 minutes without speaking. Then he looked at Catherine. "Did you edit these meeting minutes after the meetings took place?" Catherine hesitated. The minutes were revised for clarity and completeness. That is standard procedure. The judge held up 2 printed pages side by side. These are the same meeting, 2 different versions. One shows no vote on the parking policy. The other shows a unanimous vote in favor. Which one is correct? Catherine did not answer. The judge looked at the HOA attorney. "Do you have an explanation for this?" The attorney glanced at Catherine, then back at the judge. "I was not aware of any discrepancies in the minutes. I will need to review the records." The judge set the pages down. "I am ordering the HOA to release the plaintiff's vehicle immediately, with no fees or charges. I am also ordering the HOA to refund any fines or fees already paid by the plaintiff. Additionally, I am referring this matter to the Tennessee Real Estate Commission for investigation of potential fraud and misappropriation of funds. The hearing ended. I walked out into the hallway. Rachel was grinning. The former operations manager shook my hand. Catherine left without a word, her attorney following close behind. I got my car back that afternoon. The tow yard clerk handed me the keys and apologized again. He said the authorization had been pulled and that the board had been instructed to pay the full storage fees directly. I thanked him and drove home. 2 days later, I received a notice that a special meeting had been called by a group of residents. The agenda included a motion to recall the board president and to elect new leadership. The meeting was scheduled for the following Tuesday. I went. So did Rachel. So did the former operations manager. So did about 40 other residents, more than I had ever seen at a meeting before. The clubhouse was packed. Catherine tried to call the meeting to order, but residents started shouting questions before she could finish the opening statement. How much money did you make from the tow company? Why did you edit the minutes? Why are you still on the board? Catherine held up one hand. This meeting is out of order. If you do not follow the rules, I will adjourn. A resident in the back stood up. You do not get to talk about rules. You broke every rule in the book. Sit down and let us vote. Catherine sat down. Her face was red. The motion to recall was read aloud. The vote was called. 38 residents voted in favor. 2 voted against. Catherine was recalled. The 2 other board members resigned on the spot. A new board was elected that night. 3 residents I had never met, all of whom had been targeted by Catherine at some point. The first motion they passed was to suspend all parking enforcement pending a full review of the CCRs. The second motion was to terminate the contract with the tow company. The third motion was to hire an independent auditor to review the HOA finances. The audit took 6 weeks. The auditor found that Catherine had been pocketing fees from the tow company, inflating vendor invoices, and misallocating reserve funds. The total loss was over $40,000. The auditor recommended that the HOA file a civil lawsuit against Catherine and the tow company to recover the funds. The new board filed the lawsuit. Catherine did not respond. A default judgment was entered. The HOA was awarded full damages plus attorney fees. Catherine declared bankruptcy 3 months later. The tow company lost its contract with every HOA in the county. I stayed in the complex. The new board repealed the guest parking restrictions, updated the CCRs to require transparency in all enforcement actions, and instituted a policy that required all fines to be approved by a majority vote at an open meeting. The red stamped envelopes stopped appearing in my mailbox. The home health aide kept coming. She parked in the guest spot with no trouble. My father got his medication on time. I kept working my rideshare shifts. The car stayed in my driveway. No clamp, no tow hook, no warning stickers. Catherine moved out 6 months after the recall. I saw the moving truck from my window. She did not look back. The lawsuit settled a year later. The HOA recovered most of the stolen funds. The insurance company paid the rest. The new board used the money to repave the parking lot and to install new lighting. They also set up a reserve fund for legal expenses, just in case anyone else tried to pull what Catherine had pulled. I ran into Rachel at the grocery store one day. She asked how things were going. I told her the complex was quiet, that the new board was doing a good job, and that I had not seen a tow truck in months. She smiled. Good. You earned it. I agreed. I had. I hope you enjoyed the story.